We can spare the drama. Okay, recalling Gorcyca, full complaint 98, stipulation both parties are present. Ready to proceed?
So stipulated.
Yes, Your Honor, thank you.
You may proceed with cross. We'll go to the floor. At that point, we'll reconvene. Go ahead.
Mr. Lancet, I know you're an attorney. Do you have a degree in psychology, child psychology specifically?
No.
Now, as far as your November 12th report to the court, you testified that you had made these comparisons or that you had mentioned Charles Manson, correct?
Correct.
That report was meant to go to the court, correct?
It went to the parties, to the court, and the court file.
Okay. Did you intend for that report to be handed to those children?
No.
March 4, 2015. And that hearing, were those children in court before Judge Gorcyca on that date?
I don't believe they were.
How about March 18th?
May I look at the order,
Certainly.
please? Thank you. You said March 18th, Ms. Reiner?
Correct.
I don't have a recollection that they were there.
How about April 2nd, you testified as to the show cause, and there was an agreement reached by the parties whereby the mother was going to spend one day in jail.
Correct.
Do you remember that hearing?
Yes.
Were the children inside the courtroom before Judge Gorcyca on the record, yes or no?
No.
Now,
Not to my knowledge.
You testified that in August of 2014, you said the kids would sit and lock arms and would not budge, correct?
Yes.
August 21.
I'm sorry if I misspoke. August 21st, 2014.
Correct.
On that date, were those children in court before Judge Gorcyca on the record?
They were. I don't know whether or not they were actually in the courtroom when Judge Gorcyca was addressing the mother. And
Okay.
they were outside.
They were outside, but they were not inside the courtroom, correct?
Correct.
On June 24th, the plaintiff mother brought the kids in to the courthouse, correct?
Yes.
Now, did you see the court order from from June 23rd, 2015? Did you see that?
If I may refresh my recollection.
Did
and
you
look
see
at
it before today?
I'm sure I have. I'm sure I've reviewed it several times.
If you need to, go ahead.
All right, thank you. June 23rd. Well, as luck would have it, of all the ones I didn't bring, that one I don't. If I may trouble you to look at it, I'd be more than happy to refresh. Thank you.
Here, faster.
Thank you.
It's your 61.
Sorry about that, I appreciate it,
Yeah,
Judge.
it's door 61.
Thank you.
So 3-page.
Yes. Yes.
Did you have a chance to review it?
I apologize? I'm sorry?
Did you have a chance to review it?
Yes.
And that order pertains to RT and NT, does it not, for June 24th, 2015?
Yes.
You testified, sir, that deputies being present at exchange is a very unusual remedy or a very unusual step, correct?
Correct.
As a GAL, you've never heard of exchanges of children in divorce actions at the police departments?
Oh, that happens frequently, a lot of times. It's rare that it happens in the courthouse with the sheriff from the courthouse.
And on August 21st, 2014, there were deputies out there, correct?
Eventually, they were called,
And
correct.
how many deputies would you say there were?
I believe it totaled, I want to say around 6.
You have been the GAL for these children since 2010, correct?
Yes.
And in 2010, these kids were, the youngest was less than 3, correct? I'm
Yes.
sorry, less than 4.
Yeah, they were young, correct.
Between 2010 and 2015, have those children ever appeared on the record in front of the judge?
I don't believe so.
Did you ever deliver any of the court orders directly to the children? Did you ever serve them with any of the court orders?
No, I would not do that.
Nothing further.
Correct.
Your Honor, is it your belief, as it is mine, that Ms. Renier, by asking about the number of deputies at the August 21 hearing, opened that door for me to ask about what occurred that day? August 21?
2014?
Yes.
No.
Okay. All right. You testified, I believe, Mr. Lancet, that the June 24 order set forth parenting time for RT and NT specifically, or the June 23 order for June 24, correct?
Right.
And LT's parenting time was set for sometime in July, but not specifically for June 24, correct?
Correct.
LT was there,
Right.
correct?
They were all there.
They all showed up that day, correct?
Right.
Is it out of the question that the judge would have directed verbally or otherwise LT to participate in parenting time?
No.
Objection, Your Honor.
Was LT expected, by the time you got there, did you understand that LT had been expected to participate in parenting time that day because of his presence?
Objection as to who's expecting him to do what?
Your Honor,
They can ask, he's the GAL for the children. Go ahead and answer, Mr. Winston.
Yes.
Yes, what? What was
That
my
he was,
question?
that he would be expected to participate.
Okay, and so you were not at all
Even though he was
surprised?
not covered in the June 23rd order, correct?
I'm sorry, what, Judge?
Even though he was not covered in the June 23rd
Yeah,
order.
that's correct.
But regardless of whether he was covered under the June 23rd order, he refused on the record to the judge's direct question by saying, I am not going to talk to him. Isn't that true?
Yes.
Okay, and that's a direct, on the record refusal, correct?
Correct.
In the view and presence of the court once again.
Yes.
Okay. Now, Ms. Renier asked you about whether the children were present in court on March 4 or March 18 or April 2. Whether they were present or not, on those particular dates, the court orders directed changes to the children. That is, whether they were grounded from electronics or whether they were grounded to the jury room or whatever. Those orders were to the children, were they not?
Correct, through the parents.
Whether the children were present or not,
Right.
correct? And we can only presume that those orders were followed, right?
Objection calls for speculation.
We can presume that court orders are followed, can't we?
Yes.
Okay, and none of those orders changed the behavior of the children, correct?
No.
And that is why the children were brought in front of the court on June 24, 2015, correct?
Yes.
Okay, fair enough, thank you. As the GAL representing the best interests of the children, do you recall whether you had any conversations with the children explaining the court's orders?
I know I had detailed conversations with them a few times about it, and especially in that August of 2014 when they were there, and we had another meeting, I believe, in my office, and we discussed it with the kids.
And you repeatedly expressed that they must follow the court orders, is that correct?
Yes, and especially in detail, and it's in my report, on that August date.
And they weren't doing it?
They wouldn't respond, they wouldn't make eye contact, they wouldn't acknowledge anything,
Or follow the orders?
or do anything.
Or participate in parenting time?
Correct.
Okay, no further questions, thank you.
All right, thank you. Thank you, sir. Mr. Crowe.
Thank you very much.
I
I do, this is yours, I believe.
Yeah, I do need Exhibit 6.
Thank you. I don't think, is this the judges too? It might be, yes.
Hearing the right.
May I be excused, Your Honor?
You are excused, but you're not to discuss your testimony.
Okay,
with
thank
any
you.
other witnesses.
Man, straight up there.
I would carry this to this.
Raise your right hand. Myself, true self? Yeah.
I do.
You may proceed.
Thank you, Your Honor. Ms. Middleditch, good afternoon.
Good afternoon.
Would you give us your full name, please, and spell your last name?
Carrie Middleditch Wygod. My last name technically is W-I-G-O-D.
All right. Ms. Middleditch, you're an attorney, are you not?
I am.
How long have you been licensed?
Since 2001.
Okay. And you have had a fairly extensive amount of experience in juvenile matters, family law matters, have you?
Yes.
Can you describe very briefly for the court what that experience is?
Prior to entering private practice, I was an assistant Oakland County prosecutor. I started there right out of law school. And I left there in 2008, but the final 2 or 3 years I was there, I was the chief of the Juvenile Justice Unit and responsible at that time for any abuse and neglect case in Oakland County for reviewing whether or not petitions would be issued, as well as child abuse, physical abuse.
All right. And you left the prosecutor's office when?
2008?
All right. And from there went into private practice?
That's right.
Where you were handling the types of matters that you talked about just a moment ago, family law and child custody matters. Is that
Sure.
true?
Mostly outside of the purview of the prosecutor's office, although that sometimes creeps in with child protective services and what have you, but lots of contested custody matters, yes.
All right. Thank you. Ms. Middleditch, you were involved in representing the father in the Simone case. Is that true?
Yes, I still am.
All right. And when did that representation begin?
About 3 years ago, I believe it was May of 2013.
Okay. And as you've indicated, you're continuing in that representation today. Is that true?
Yes.
All right. Fair to say that during the course and time that you've been involved in representing the father in this matter, there have been many, many hearings and issues regarding parenting time?
Yes, over the last 3 years, yes.
All right. And again, because the court's already heard some of this testimony, can you just briefly summarize for us what those problems have been and what action you took?
Objection as to relevancy, objection cumulative.
Your Honor, we heard...
Go ahead. This is, I'm very familiar with the file, but go ahead.
You can summarize.
Thank you, Your Honor.
Since my involvement, I have filed a number of motions, responded to a number of motions, primarily dealing with custody and parenting time issues. There have been a couple other issues as it relates to the enforcement of the judgment of divorce, but by and large, the majority of my time has been spent on custody and parenting time issues.
And what's your goal been with regard to all these motions and things that you've filed?
For my client to have a healthy relationship and have a really parenting time with his children.
Okay. Has that occurred up to now?
Certainly in the last year, he has had some parenting time with his kids.
Objections to what's happened in the last year?
All right. Let me be a little more precise with my question then, Your Honor. Up until June the 24th of 2015, had there been any meaningful parenting time that your client had?
No.
Okay. Were there other efforts that you made along the way, short of this contempt hearing that we have heard so much about on June the 24th, to secure parenting time?
Yes.
Okay. And again, the court has heard some of this testimony, but just briefly talk about the different types of avenues you tried in order to get parenting time.
We tried a number of avenues where there was consultation with the guardian ad litem as well as counsel for mother, where we tried different things to try to help the kids and facilitate a relationship, whether it was having different kids come together. You know, there are 3 siblings, so maybe one-on-one or 2 at a time. We changed locations, whether it be at a restaurant that the kids liked or bowling or other sorts of activities, arcades, what have you. We tried it at my client's home. We tried it at my client's home with mother participating in at least the initial part of the visit. We tried the children talking to the friend of the court counselor, Tracy Steeb. I think initially, when I initially got on the case, there may have even been some counseling that was ordered for the children. There was a number of avenues that we tried.
Good. And those avenues included having a number of different therapists work both with the children individually and with the family collectively, right?
Yes, some of that before my involvement.
Okay. And as you described, efforts were made to have parenting time occur at a variety of different locations, right?
Yes.
Some of which you've already described, but it also included things like parenting time at a library, right?
Yes.
At a mall, right?
Yes.
At a restaurant?
Yes. Various restaurants, actually, that the children liked.
All right. And it's true, is it not, that there is even an attempt to have parenting time at a friend of the mother's to see if hopefully that would be a breakthrough?
I believe that was prior to my tenure, but yes.
All right. And none of those really seemed to work, did they?
No.
Your Honor, I have no further questions. Thank you.
May I have one moment, please? Good afternoon, Ms. Middleditch.
Good afternoon.
You said that you worked at the Oakland County Prosecutor's Office before going into private practice, correct?
Yes.
And did you know Judge Gorcyca while she was with the Oakland County Prosecutor's Office as well?
Yes.
On June 23rd, 2015, you attended a hearing in front of Judge Gorcyca, and that was the date that the order for parenting time for RT and NT was signed, correct?
Yes.
And do you know what I'm doing with the initials?
I think so.
Okay, I'm using the initials because we're trying to avoid using the children's names.
I understand. I will try to do the same.
Thank you. And so you were at that hearing, correct?
On the 23rd?
Yes.
Yes.
And do you remember advising Judge Gorcyca that your client is going to be out of town for 2 weeks and it's not fair for him not to see his children for 2.5 weeks? Do you remember advising Judge Gorcyca?
I do not recall advising
Okay.
her that. Do you have the transcript for me to review?
Yes, I'm going to get that for you in 1 second.
transcript would be your 10, I believe.
And that's,
Exhibit 10. That's what you're looking for.
I got it. Let me hand you what has already been admitted as Examiner's Exhibit 10, and let me direct you to if I may have one moment. There we go. Starting on page 8, line 23. Can you read that and the top of the next page?
Yeah, read it to yourself.
Did you have a chance to read it, ma'am?
Yes, I did.
And does that refresh your memory as to your advising Judge Gorcyca with respect to the dermatological checkup?
Yes.
That your client is going out of town for 2 weeks and it's not fair, that he's not going to see his children, or the children will not see their father for more than 2 weeks?
Yes.
Did you attend the July 10th hearing, July 10th, I'm sorry, 2015 hearing before Judge Gorcyca where all the media was there?
Yes.
And in fact, the connection with your client was made via telephone, was it not?
Yes.
To your knowledge, your client was where?
My client and my communication is privileged.
I'm sorry?
My communication with my client is
Location.
privileged. His location?
His
That's all I
location,
wanna
that's
know.
all I'm asking.
At the time, I believe he was at the airport.
In the United States?
I don't believe so. I think in Israel.
Thank you.
Any further, counsel?
Nothing.
I didn't know we'd break ground. Thank you.
Thank you. You may sit down.
Thank you.
You have to discuss your testimony with any other witness.
Thank you. Am I excused, Your Honor?
You are excused.
Thank you.
But you're still subject to the sequestration.
I understand.
Right, thank you. All right.
Yeah.
We can get started with the next one. We'll start with 4.
Thank you, Your Honor. The respondent calls.
Reconvene around 9.
Thank you, Your Honor. The respondent calls Deputy Randy Maloney.
All right, Deputy. How are you?
Fine, sir. Yourself?
Good. Come again. Promise I'll put yourself again.
Yes, Your Honor.
Have a seat.
May I proceed, Your Honor?
You may proceed.
Thank you.
Go ahead,
Sir, could you please state your name for the record?
Randy Maloney.
Thank you, Deputy Maloney. It's my understanding that you are currently a sheriff's deputy for the Oakland County Sheriff's Office.
Yes, I am.
How long have you been a sheriff's deputy for Oakland County?
23 years.
23 years. What type of training is required to be a sheriff's deputy?
Sheriff's Deputy, 120 hours of Corrections Academy, and you can do the Police Academy if you wish so, but you don't. It is not necessary unless you want to go the road.
Okay, did you do the police academy
Yes,
also?
sir.
Okay. When did you graduate?
92.
Excuse me?
92.
Thank you. During your training, did you receive any instruction on how to properly arrest and or detain an individual who's being taken into custody?
Objections to relevancy in the training?
Let's just focus on what they did and what the policies and procedures are.
Okay.
Let's just cut to the chase here.
All right, thank you. Understood. Deputy, are you currently assigned as a sheriff's deputy to Oakland County Circuit Court in Pontiac?
Yes.
That's the 6th Circuit?
Yes.
How long have you been appointed there?
Give or take 12 to 14 years, 13, 14 years.
Okay, and over those 13 or 14 years, what are your duties as a sheriff's deputy at Oakland County Circuit Court?
Safety and security of the building and its staff.
And does that entail kind of going around the building and checking in each of the courtrooms?
Yes, sir.
Okay. And that's something that you do every day?
Every hour, every few minutes, yes, sir, all day long.
Okay. Did you receive any additional training for your assignment to the circuit court?
No, sir, just on-job training.
So the rules or protocols of the Oakland County Sheriff's Office would apply to your role as a sheriff's deputy at Oakland County Circuit Court?
Yes.
Okay. And is it true that there are specific rules and protocols of the Oakland County Sheriff's Office regarding detention and handcuff of individuals being taken into custody?
Yes.
Okay, and what are those rules and procedures of Oakland County?
Anybody taken out of the courtroom is handcuffed behind their back unless they have a physical disability like a broken arm or something. Then, of course, you can't handcuff them people.
Okay. But unless it's impossible, you will always put handcuffs on an individual who's being taken into custody?
Yes.
Okay, and that includes children?
Yes.
Okay. And is that for safety purposes?
Yes.
The safety of whom?
For the individual and the welfare of the deputies and the staff.
And also
The public.
The public, okay. So failing to put handcuffs on a detainee would be unsafe for you?
Yes, sir.
It would be unsafe for the detainee?
Yes.
It would be unsafe for the litigants? It
Yes.
would be unsafe for the public in general?
Very much so.
Okay. Is it also a rule or protocol in Oakland County that detainees are prohibited from speaking with friends or family after being placed in handcuffs?
Yes.
And why is that?
Speaking and or hugs, handshakes to pass contraband,
Okay.
Any other-
Pardon me, continue.
any other weapons or anything they might pass, and hugging or a handshake.
Okay, to avoid the exchange of contraband or weapons, essentially.
Yes.
Okay, and that again, it goes to the safety of the officers,
Yes.
the safety of the detainee,
Yes.
the safety of the public,
Yes, sir.
okay, and so on. Okay. And these are rules and protocols of the Oakland County Sheriff's Office,
Yes.
not of the 6th Circuit necessarily.
No, sir.
Okay. During the course of your employment and your assignment over the past 13 years or so to the 6th Circuit, has any judge ever asked you not to comply with the rules or protocols of the Sheriff's Office?
No, sir.
Okay, I'll continue. Thanks, John. During your 14 years assigned to the Oakland County Circuit Court, have you had an opportunity to conduct your duties in the courtroom of the Honorable Lisa Gorcyca?
Yes.
Okay. And in particular, on June 24th, 2015, actually, before I jump ahead there, during the course of your employment, did you have any involvement or interaction in the divorce matter of Simone versus Simone, pending at the time before Judge Gorcyca in August of 2014?
Can you repeat that question?
Sure. During the course of your employment as a sheriff's deputy for the County of Oakland, did you have an opportunity to have any interaction with any of the parties in the Simone versus Simone divorce action in August of 2014?
There was one day in August, I do remember, yes.
And Judge, I know you've made a ruling on this, but Ms. Rainier, during the examination of Bill Lancet, asked in August of 2014 if any deputies arrived or how many parties arrived to the children who were standing outside of the courtroom.
Were you one of the gang of 6? Were you one of the gang of 6 on the August 2014 date?
6? I was there, sir. Whether there was 6?
Okay. All right. Thank you.
I have the transcript of it already, so.
Okay, and Judge, if I may just,
So, the 24th.
thank you, if I may just echo the offer of proof that was made during Ms. Harris's testimony regarding her presence on August 21st of 2014. The same goes to the deputy. Thank you, Your Honor. All right, and then the next occasion that you had involvement in the Simone versus Simone case was in June of 2015. Is that correct?
Yes,
Specifically June 24th of 2015?
I believe so, yes.
Okay. And at that time you were working in your capacity as a sheriff's deputy for Oakland County?
Yes,
And you were present at the hearing involving the 3 Simone children?
yes,
Are you aware that that hearing was a civil contempt hearing?
yes.
Okay. While you were present in the courtroom on June 24th, 2015, did you hear the oldest child, who we've been referring to as LT in this case, did you hear LT tell Judge Gorcyca that he would not participate in parenting time with his father?
Objection.
Yes.
Relevancy.
Oh,
Students, hear your answer?
go ahead.
That was a yes.
Okay. And that statement by LT was made to Judge Gorcyca while on the record, right?
Yes,
Okay. Did you hear Judge Gorcyca hold LT, the oldest child, in contempt?
yes.
Okay, what did you do next after hearing Judge Gorcyca hold LT in contempt?
Liam, is this
Correct.
Yes.
Correct, LT is, yes, the oldest.
the oldest one? Handcuffed behind his back, escorted out of the courtroom, and put in the probate department deputies. They transport all juveniles.
Okay.
And I came back to the courtroom.
And so if we could take just a step back after you placed the handcuffs, or at the time you placed the handcuffs on the oldest child, LT, did Judge Gorcyca order you to handcuff LT?
No, she did not.
Okay. Did Judge Gorcyca give you any instructions whatsoever regarding the detention of LT?
No, she did not.
Isn't it true that you handcuffed LT because the rules and protocols of the Oakland County Sheriff's Office, about which we previously spoke, required you to do so?
Yes, sir.
Okay. And is it the policy regarding the handcuffing of individuals being detained, is that policy the same for individuals who are sentenced to detention for a crime, just as well as individuals being held in contempt?
Yes, sir.
Okay, and those are the policies of Oakland County?
Yes, sir.
And the policy prohibiting a detainee from speaking with friends or family members after being handcuffed also applies to individuals being held in contempt?
Yes, sir.
And that's, again, so to avoid the exchange of contraband or weapons?
Yes, sir.
Objection asked and answered.
This is a...
It's been covered.
Okay.
It's redundant.
Thanks, Your Honor. And you mentioned that you escorted LT out of the courtroom,
Yes.
and you took him to probate detention,
Yes.
because those are the policies of Oakland County.
Yes.
Okay. Now, after you took LT to probate detention, what did you do next?
I returned back to the courtroom.
Okay, so were you present in the courtroom of Judge Gorcyca at the time of the contempt hearing regarding the other 2 children to whom we've been referring as RT, who's the middle male child, and NT, who is the youngest female child?
Yes.
Okay, so you were present for both hearings regarding those 2 individuals?
Yes.
While you were present, did you hear RT, the middle child, tell Judge Gorcyca that he would not follow her orders and that he would not have parenting time with his father?
Yes.
Okay. Did you also hear Judge Gorcyca hold RT in contempt of court?
Yes.
And what did you do next?
Same. Secured, handcuffed behind his back, escorted out.
Okay, and just like with the oldest child, LT, Judge Gorcyca didn't give you any instructions regarding the handcuffing of RT?
No.
Okay. And what did you do next?
Handed off to probate and returned back to the courtroom.
Okay, and by the time you returned to the courtroom, was the proceeding, the contempt hearing, still going on?
Yes.
Okay. And when you got back to the courtroom after taking RT to probate detention, what did you do next when you got to the courtroom?
The proceedings were going on with the littlest one,
Okay.
and she went to probate also.
Okay, and so you heard the youngest child, NT, tell Judge Gorcyca on the record that she was not going to follow the judge's orders and that she was not going to have parenting time with the father, correct?
Yes.
Okay. And you also heard Judge Gorcyca hold NT in contempt of court.
Yes.
Okay. And what did you do after Judge Gorcyca held NT in contempt?
Handcuffed behind the back, escorted to probate.
Okay. Just like the previous two.
Yes, sir.
Okay. And again, regarding NT, Judge Gorcyca did not give you any instructions regarding the handcuffing of NT.
No.
Okay. She didn't give you any. Excuse me. Strike that. In your opinion, in your 13 years as a sheriff's deputy for the County of Oakland, assigned to the Sixth Circuit Court, were your actions on June 24th, 2015 related to the detention and transportation of the Simone children in compliance with the Oakland County Sheriff's Office's policies and procedures?
Yes.
Okay. Thank you, Your Honor. I don't have any further questions.
I'm sorry, can you tell me your last name? Is it Maloney or Mahoney?
Maloney.
Maloney.
With an L.
Mr. Maloney, in Oakland County Circuit Court, the courtrooms are not staffed with deputies on a regular basis, isn't that correct?
Correct.
And so, if the courtroom requires a deputy, a phone call is made and then one of you goes up there, correct?
Objection, Your Honor, relevance. We weren't talking about anything before the June 24th hearing.
Let's talk about the 24th, or August 10th for that matter.
Do you want me to repeat the question?
No, I'm waiting for the judge to let me
Go ahead,
answer it, Your Honor.
go ahead. Yeah.
Yes, sir. We can be called up, or we can find it on our routes, just walking around and stopping in.
Okay.
So we do it both ways.
And in this case, on June 24, 2015, your presence was required up in the courtroom, correct?
I stopped and took a peek in the courtroom and just hung out.
Okay. Were you the only deputy in the courtroom on that day?
For a short amount of time, yes.
And then what happened? Somebody else joined you?
Probate joined me.
I'm sorry, when you say
Some
probate,
officers-
what does that mean?
Some officers from probate.
And when you say some officers, are you talking about more than one?
One or two, I believe.
Okay. So there were a total of up to 3 officers in that courtroom, correct?
Could be.
If you, and I'm sorry, I don't know the layout of Circuit Court. Are the deputies at some central location? Do you have an office?
Down in the basement?
And when a call comes to your office that additional deputies are required for a courtroom, that has a meaning to you that there could be some reason for that and could be problems, correct?
Again, Your Honor, objection. We're here to talk again about the June 24th hearings.
It could and could not.
Okay. Now, on this occasion, when you went up there on 6/24/2015, did you see any commotion in the courtroom?
I was on rounds. I didn't go up.
Okay.
There wasn't a phone call.
All right, but when you got to the courtroom, did you see any commotion, any problems, any fights?
No.
Okay. At any point in time, did LT resist you in any way? Did he fight you?
No.
Were you afraid of him?
No.
How about RT, the middle child?
No.
How about the little girl?
No.
Objection, Your Honor, relevance.
Overruled.
Now, you also testified that when you escort someone who's in custody, you have to make sure that they are secure, correct?
Yes.
And because you have to make sure that they're secure, you can't let anybody have contact with them, can you?
No.
So friends, family, whoever wants to have any contact with them, whether they want to say something or pass something, it's your responsibility to make sure that you take that individual, transport them to wherever they're ordered to be, and then whoever wants to visit them, they can do it there.
Yes.
Now, when you were placing the handcuffs on that youngest of the 3 children, did you hear her sobbing and crying?
No.
You didn't. Thank you.
No, I didn't.
Okay. All right, thank you. Anything further?
Nothing further, Your Honor. Thank you.
Thank you. You may step down.
Yes, Your Honor.
And you're not discussing testimony with any other witnesses, sequestration of it.
Yes, Your Honor.
We'll resume tomorrow at 9. Thank you.
Right.
There's 9 witnesses, and we've made some progress.
Thank you, Your Honor.
Okay, 9 a.m.
Your Honor, it's not on the record. Do you know if we can leave our materials here or we can't? Thank you.
You guys all in your chambers here?